Thank you for joining us this afternoon. My name is Chell Miller. I'll be adding some logistical information in the chat for you, but the webinar will have live captions. You can view these captions as subtitles by clicking the show captions or show subtitles on the bottom of your screen. And I will turn it over to Judge Stein.
Thank you, Chell, and good afternoon, everyone. I wish I could see all your faces, but that's the one limitation of Zoom. In any event, I do welcome you to the first installment of the 2023 Disability Law Series on Civil Rights and Individuals with Developmental Disabilities. I'm Leslie Stein. I'm the director of the Government Law Center and home of the Institute on Aging and Disability Law at Albany Law School. This is the first program in this exciting series of 5 programs, which, as you might expect, has been organized by a number of individuals. Special thanks to the members of the Aging and Disability Law Committee members, Lawrence Faulkner, Paul Keatsman, and Sheila Shea, led by our own Professor Rosemary Bailey. Also, many thanks to the Government Law Center staff members who have handled all the arrangements for this program. The topic of today's program is an overview of civil rights and individuals with developmental disabilities. The other programs in the series will be held on February 9th, March 9th, March 30th, and April 13th, all at 1 o'clock. They will address consent in healthcare decisions, consent of adults in adoption and marriage decisions, guardianship for people with developmental disabilities, and potential statutory reforms for the protection of civil rights of people with developmental disabilities. We hope you will join us for as many of those programs as possible. We have an exceptional group of panelists today who will be introduced by our moderator, Tara Ann Pleat, co-owner of Wilcenski and Pleat LLC. Ms. Pleat is a graduate of Albany Law School and practices in the area of estate planning and administration and long-term care planning. And with that, I will turn it over to Ms. Pleat.
Thank you, Judge. Hello, everybody. Just a couple of housekeeping items at the very beginning. You have some information regarding CLE credit that's in the chat, so I'd like to draw your attention to that if you can see it. Just wanted to let you know that if you would like to ask questions, depending upon what those questions are and their applicability at the time, we'll either answer them at the end of each segment, or we will wait until the end of the presentation and the time allotted. We're just going to kind of see how that goes as far as the questions and the content of our discussion today. But want to welcome you and thank you for being here. We're going to get ourselves started right now with our first presenter, who is Roger Bearden, the Executive Deputy Commissioner of the New York State Office of Developmental Disabilities. And Roger is going to be talking to us about the landmark Olmstead decision. And with that, I'm happy to turn it over to Roger. Thank you.
Hi, good afternoon, all of you who I can't see. It's a pleasure to be here. I have the honor, I guess, of being the first speaker in this great series, and I'm grateful to the Government Law Center for inviting me. I've been in a position where I have been a plaintiff's attorney on Olmstead cases. I have been worked in the governor's office, working on Olmstead issues, and most recently, as indicated, I have been at the Developmental Disabilities agencies in New York, working on the operations side. Really wanted to talk about, I think, 3 main things today. The first is the Olmstead decision itself. The second is the work in New York that preceded Olmstead, but is very, very important as we understand the landscape in New York. And then the third item is looking a little bit towards the future. So first, in terms of Olmstead itself, the case concerned 2 women who had both mental illness and developmental disabilities, named Lois Curtis and Elaine Wilson. Those of you may know Lois Curtis actually passed away this fall. And I would recommend reading any number of obituaries about her remarkable life. So each of them had been confined in a hospital setting for a number of years beyond the time in which they had been determined ready for community-based treatment and programming. And this was in the state of Georgia, and Georgia didn't have a sufficient community-based system to support these two women. The case itself ended up at the Supreme Court in 1999. It had a long journey through various lower courts, and really the base of the plaintiff's complaint in that case was founded in the Americans with Disabilities Act, which had been enacted in 1990, as the act itself provides, to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. And part of the findings that became significant in the Olmsted decision itself was that, you know, historically society has tended to isolate and segregate individuals with disabilities, and such form of discrimination against individuals with disabilities continues to be a serious and pervasive social problem. So as part of the ADA Title II, which is the section that's applicable to public entities, states, that says that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination by any such entity. And then under Title II, the Attorney General of the United States had the authority to adopt regulations, which kind of further clarified what Title II provides, and those regulations provide that that public entities must administer services, programs, and activities in the most integrated setting appropriate to the needs of qualified individuals with disabilities. And there's a preamble in the Title II regs that speaks most directly, and it was important in the Olmsted decision itself, that's saying that the most integrated setting is one that, quote, enables individuals with disabilities to interact with non-disabled persons to the fullest extent possible. So it is a form of discrimination that under the so-called integration mandate to segregate individuals with disabilities more than necessary. So then in Olmsted, the Supreme Court took account of the facts of both Lois Curtis and Elaine Wilson, who, as I said, had been found to be capable of receiving services and supports in the community. And the barrier was that the state of Georgia did not have a system that would provide those supports. And so they were in this highly institutional environment. And the Supreme Court in 1999 held in Olmsted VLC that public entities are required to provide community-based services to persons with disabilities when A, such services are appropriate, B, the affected persons do not oppose community-based treatment, and C, community-based services can be reasonably accommodated, taking into account the resources available to the entity and the needs of others who are receiving disability services from the entities. So that third section functions as kind of a limitation on the obligations of states to provide community-based services, and also makes clear that a particular plaintiff doesn't so-called jump the line if there are others who are similarly situated who maybe have been waiting longer. And the court went on to say in order to comply with the ADA integration mandate, public entities must reasonably modify their policies, procedures, or practices when necessary to avoid discrimination. So you have in your materials the Olmsted VLC decision, and it's a very interesting decision. It's a plurality decision. Won't go into all the various opinions in it, but that's the essence of that document. Now, when I said that New York State actually has kind of a history around Olmsted previous to Olmsted, and that, of course, is the Willowbrook case, and this goes back to the late 60s and early 70s, and then in particular in 1972, when Geraldo Rivera exposed the incredibly inhumane conditions and neglect and abuse that was taking place at the Willowbrook State School in Staten Island. And a set of plaintiffs brought litigation in 1972. Of course, this is well before Olmstead, well before the ADA had been enacted, and their claims were constitutional in nature. Interestingly, the First Amendment claim that talks about confinement depriving of people of their ability to associate. So if you're in an institutional model and unable to associate with those without disabilities, the violation of right to association, 4th, 8th, 14th Amendment claims in terms of rights that people have under those. And then interestingly enough, there was even a 13th Amendment claim because the people at the Willowbrook State School were required to perform labor without compensation. And the 13th Amendment, of course, prohibits involuntary servitude. So that Willowbrook case was brought in 1972. There's a whole series of, there's a consent decree originally, there was a whole series of subsequent documents. The currently operative document, which is in your materials as well, which is the 1993 Willowbrook permanent injunction, creates a whole set of entitlements to community services for the former residents of the Willowbrook State School. The Willowbrook itself was in September of 1987 closed, or as Mario Cuomo, the governor at the time, said, officially and forever closed. But the permanent injunction, which I said is in your materials, it's actually on OPWD's website as well. It continues to govern those members, because many of the people placed in Willowbrook State School were very young children. So there continue to be thousands of people. So with that backdrop, and fast forwarding beyond Olmstead, in November 2012, Governor Andrew Cuomo issued an executive order establishing what was called the Olmstead Development and Implementation Cabinet. I had the privilege of chairing that body, and the charge to that group was to develop an Olmstead plan for the state of New York. And Olmstead plans typically are affirmative-looking documents that seek to bring states into compliance with the requirements of Olmstead proactively, and potentially in avoidance of the necessity for litigation to force compliance. So that cabinet met with hundreds of stakeholder groups, did a lot of work internally with various state agencies, and developed a set of recommendations which were included in a document, which once again is also in your materials. Really looking both at places where people live, so looking at certain targets to decrease the reliance on institutional forms of care and increase the availability of community-based settings, supported housing, and then to reform the way choice for people with disabilities was really understood, and assessment of the needs, and then also some examinations in that document around increasing employment outcomes, increasing transportation, and also preventing people with disabilities from being, say, for example, stuck in the criminal justice system when there might be a more appropriate setting for them to receive the services that they need. One of the components of the examination that was done at the time was an examination of whether there was an effective advocacy in New York State to assist people who may be subject to unnecessary segregation and isolation under the ADA. And so one of the recommendations that the Olmstead Implementation Cabinet made was that what had previously been a state function, which was an investigative oversight function, would move to a nonprofit. And for those of you who are familiar with the systems, every state has a federally authorized protection and advocacy system that serves to safeguard the rights of people with disabilities, and that is now known as Disability Rights New York. They have continued to pursue litigation in the area of Olmsted. I will highlight just one piece of it for folks who are interested more. There's a whole page worth of litigation on their website, but the O'Toole v. Cuomo litigation, which was actually initiated back when Pataki was governor, reached a settlement in 2013, and that had to do with adult homes residents with a serious mental illness who, as alleged, would be able to thrive in more community-based settings and not in the institutional adult homes case. So as I said, in 2013, the settlement agreement was reached, and the state was committed to providing scatter site supported housing for all adult home residents with serious mental illness so that they could live in the most integrated setting appropriate to their needs and with appropriate community-based services and supports. I would highlight another aspect of the Olmsted report was looking at guardianship in New York State, and I think there'll be more discussion from a subsequent panelist about some of the reforms that have been enacted. In July of 2022, Governor Kathy Hochul signed a bill into law which established for the first time in New York State supported decision-making as an alternative to and less restrictive alternative to guardianship for people with intellectual disability and developmental disabilities. Obviously that was a way to maximize their autonomy to make the decisions for themselves, as opposed to having a substituted decision maker who would make those decisions. So I'm nearing the end of the time that I have. I just want a couple of notes in terms of looking forward and what does kind of Olmsted look like as we move forward. So one element of Governor Hochul's agenda in supporting people with disabilities is involved the appointment last year of a chief disability officer, Kim Hill, an effort to review the 2013 Olmsted report and give consideration to where have we achieved its aims and where have we not yet gotten there, and to try to to revitalize. There is a statutory body called the Most Integrated Setting Coordinating Council, and that body, which was established around the same time as the ADA, has a responsibility. Actually, it was established around the time the Olmsted decision was reached. Has the responsibility for monitoring and overseeing the state's implementation of the Olmsted decision, and so there's an effort afoot to kind of revitalize that body. Certainly during the COVID period, there were a lot of attention to other matters, and so I think there's an increasing focus on something that I think will need some attention within this community, which is the there will be the intersection between race, gender, ethnicity, other forms identities, and disability, and how it is that the state better serves people who may be impacted by multiple challenges in accessing supports and services and in living lives of full participation in the community. So let me pause there and flip it back to Tara Pleat, who I think is our coordinator, to see if there's anything that has come in the question box that I should address at this moment.
No Q&A in the question box, but I have one, which you can choose to tell me we'll defer it until the end. But the question that I had is, just in looking at the landscape that we have today, sort of broadly, what do you identify as the biggest challenges to the continued implementation of sort of the spirit of the Olmsted cabinet and the plan that your group facilitated?
Sure. So one of the biggest challenges in multiple sectors, not just the human services sector, is the availability of a workforce. So a lot of the community-based supports that people need in order to thrive in the community have been really, negatively impacted by the COVID-19 pandemic, the workforce shortage that that is not limited to the human services sector. And so, even for folks who may be able, who be determined, able, and qualified for the relevant programs, providers of different those services are really struggling with identifying and recruiting and retaining that qualified workforce. So so for people who need that type of support, it can be a real challenge to access it at this current moment.
Yeah, we're participating in a program yesterday and having just a general discussion about the fact that the birth rate is down 20% since 2007 and continues to be on the decline. So when you think about the workforce issue, as you say, not just, it's kind of in all domains. It's going to be something that's going to be an interesting challenge for those domains to address and try to incorporate.
Right, and there certainly are, and we may go far down a rabbit hole beyond the scope, but there certainly are some solutions in terms of model redesign, use of technology, assistive technology that may be helpful in people achieving their life outcomes. But clearly there are some supports that can only be provided by a human being, and those require that person to be present and within the workforce and so on.
Right. Roger, as we've been talking, 2 questions have come in, and the first one says, it's great to have a public policy that requires people to enjoy full participation in the community. However, this is really limited when you don't have appropriate services and programs to meet the needs, which I think is maybe not a question, but a comment, and consistent with what you are just saying. So I think it requires, us collectively to try to think big picture about what are the ways to solve some of those challenges. And then subsequently, another participant, Chris Lyons, who is the executive director of a disability service organization in Saratoga County, asks if you see self-directed services as a fast pathway to access more independent environments in our communities. And do you see any challenges in the self-direction places as well? Sure,
and depending upon the listener, they may or may not be familiar that OPWDD in November did issue its own strategic plan, which kind of sits under the Olmstead, but in terms of self-directed services, self-direction is a payment methodology, right? Rather than the budget being controlled by a provider entity, a family or the individual would control the budget, but they're still hiring staff and purchasing services. So it's another way of getting to those services, but it does at the base, there has to be a person who's willing to provide that service and be hired. So right. It's certainly something, if you look at the growth of the service system for IDD in New York State, that is an area of massive growth. And so people are voting with their feet, if you will, towards that service system, to that mode of service delivery mode, but it's not a panacea for the same reason.
Excellent. And right now, Roger, thank you so much for that overview and the discussion. We are going to move on to our next presenter, who is Prianka Nair from Brooklyn Law School. She is an assistant professor of clinical law and co-director of their Disability and Civil Rights Clinic. And Prianka is going to talk to us today about the principle of capacity and its role in decision making. So Prianka, the floor is yours. Thank you.
Oh, thank you so much. Thank you for including me as part of this panel. And it's also really exciting to be able to talk about legal capacity generally. I'm going to try and share my screen. I have a PowerPoint and you should have copies of those slides, but I am hopeful that this will work. Is everybody able to see the PowerPoint?
Yes.
Perfect. Okay. So I want to start really, and my purpose in this presentation is to give you a sense of what legal capacity is and what capacity and incapacity is, and really to point out the ways in which ableism have influenced who we designate as having capacity and who we designate as not having capacity, and therefore being unable to exercise legal capacity. So legal capacity refers to the legal right of an individual to make decisions, engage in certain transactions, enter contracts, exercise their rights in court, essentially be recognized as a holder of rights. And here on this slide, I have included the language that's actually used in Article 15 of the Convention on the Elimination of All Forms of Discrimination Against Women, because I think it exemplifies this idea best. And this provision states that state parties shall accord to women in civil matters a legal capacity identical to that of men and the same opportunities to exercise that capacity. In particular, they shall give women equal rights to conclude contracts and to administer property, and shall treat them equally in all stages of procedure in courts and tribunals. And I think this provides a good sense of what capacity means, namely the ability to have rights, act on those rights, and be recognized as having rights. A concept that is distinct from legal capacity is that of capacity or incapacity. Capacity is the term frequently used to refer to the ability of an individual to appreciate or understand their decisions. It's tied to the ability of a person to reason, deliberate, appreciate one's circumstances, understand and communicate choices. And some laws frequently link capacity and legal capacity together. So if one is adjudged as incapacitated by a court of law, then one's legal capacity might be curtailed. And guardianship is one of those legal mechanisms by which a person's legal capacity could be terminated based on the assessment of a person's ability or capacity to make decisions. And so what I've extracted here is a provision from Article 81 of the Mental Hygiene Law, which, and this particular provision outlines how a court must make a finding of incapacity, namely by determining that a person is likely to suffer harm because they cannot provide for their personal or property needs, and that they do not adequately understand and appreciate the nature and consequences of that inability. I just want to take a moment here to point out that the concept of incapacity is really a construct, a legal fiction that permits the state to legitimately intrude, as Charles Sabatino and Erica would put it, into the personal and property affairs of an individual. And I particularly liked this point that they make, that legal capacity so conceived is important precisely because a legal fiction is determined by prevailing values, knowledge, and even the economic and political spirit of the time. The criteria or elements needed to establish legal incapacity are the products of a society's prevailing beliefs concerning individual autonomy and social order, tempered by the restraint of legal precedent. Just as societal values and needs have evolved over time, so will the legal criteria for capacity and incapacity. And I think this makes the really clear point that the line between capacity and incapacity is very much shaped by those prevailing values, knowledge, economic climate, social beliefs and culture. And my particular focus is about how ableism has shaped the discourse around capacity and legal capacity. I apologize, I'm toggling between screens. So I want to stop for a moment and talk a little bit about ableism and kind of provide a definition. I feel like I'm preaching to the choir here. I feel like many of the attendees are well versed in talking about ableism and understanding it and understanding how it manifests. But I've always found a definition to be helpful. Ableism refers to practices and beliefs that treat people with physical, intellectual, or psychiatric disabilities as being inferior. It's linked to the idea that disability is something that needs to be eradicated or fixed in one form or the other, and it assigns values to bodies and minds. And I've included here a working definition of ableism by scholar and activist Talila Lewis, developed with a community of disabled Black and other negatively racialized folk, as she puts it. And this definition highlights how the value that's assigned to bodies and minds is very much based on socially constructed ideas of normalcy, productivity, desirability, intelligence, excellence, and fitness, and those ideas are very much rooted in eugenics, anti-Blackness, misogyny, colonialism, imperialism, and capitalism. The manifestation of ableism in the legal system and in social structures and even in everyday interactions is very much complicated by race, gender, sexuality, class, and other minority statuses. Coined in 1989 by Professor Kimberly Crenshaw, the term intersectionality refers to the way multiple individual characteristics intersect and overlap with each other. And Professor Crenshaw actually used the term to shine a light on the dynamics in discrimination law, where courts overlook the experience of people who might share multiple oppressed identities. So people with disabilities have multiple roles and identities, and in being members of more than one group, they can simultaneously experience both privilege and oppression. And when we are thinking about solutions to problems and solutions to ableist problems, these are complicated by the discrimination that people might experience because of the intersection between disability and other identities. Historically, and I think this is a striking example of how everything intersects, legal capacity has been denied to numerous categories of people, and the reasons for that denial have really existed at the crossroads of racism, sexism, and classism. Throughout history, in many countries, women have been denied legal capacity and prohibited from voting. Enslaved people were also denied legal capacity, and historian Douglas Bainton has pointed out that disability was often the reason that was used by enslaved people, that was used to deny these aspects of the population, that is, enslaved people, suffragettes, legal capacity. They were deemed to be physically and mentally unable to handle the responsibility of suffrage or equal standing before the law because of their race and sex. And these are ableist arguments that value certain bodies and undervalue others based on perceptions of ability, but they're also sexist and racist ideas. So that's just a way in which everything might kind of fit together. By no means a perfect fit, but my specific focus here is on the history of denying legal capacity to people with disabilities, particularly people with intellectual and developmental disabilities. In Western legal traditions, the king had the power to act as the parent of the country and protect the person and property of whom the state deemed to be mentally incompetent or incapacitated. In Heller v. Doe, a case that from the Supreme Court that outlined the way in which this doctrine operated, as well as the particular way in which people with IDD, intellectual and developmental disabilities, were treated differently and unequally. And essentially what the court noted was that the king could profit from the estate of a person with an intellectual or developmental disability while providing him with necessaries in a way that the king could not in other circumstances. For instance, the king could not profit from the lands of someone who was judged to be mentally ill. So the parens patriae law would become the basis for the state to make sweeping decisions for people with disabilities, particularly intellectual and developmental disabilities, but certainly people with psychiatric disabilities, that would frequently deprive them of equal standing under the law and promote the mass institutionalization that would come in the mid-19th century in residential schools, prisons, and penitentiaries. Another force that has historically driven the denial of legal capacity for people with intellectual and developmental disability. And just before I do that, I do want to point out that in this case, the Supreme Court proceeded to use this justification, this distinction between people with intellectual and developmental disabilities and people with psychiatric disabilities, use that distinction to justify or find as constitutionally valid Kentucky's civil commitment laws that vastly that discriminated in very fundamental ways between people with intellectual disabilities and people with psychiatric disabilities. The court found that this was reason good. There's old history and support for that kind of discrimination, and so continued to perpetuate that discrimination in this case. That's a discussion for another day. But another force that has historically driven the denial of legal capacity for people with IDD, or another few reasons, is the fear, the suspicion, and misunderstanding of disability. In the 19th century, people with disabilities were broadly grouped with others who required the assistance of the state, including widows, orphans, and the elderly, and they were placed in poor houses and viewed with suspicion because of their reliance on the state for assistance, and they were not trusted to care for themselves. Disability also became synonymous with criminality, with many reformers setting up penitentiaries to house both the people with disabilities as well as those who had committed crimes. Disability-related behavior was also criminalized, which was another way of populating the penitentiaries. And this further cemented the public perception that there was a link between disability and criminality, and led to the increased incarceration of people with disabilities. And a notorious example of this were the ugly laws that proliferated in the cities across the United States in the mid-19th century that criminalized the very presence of people with disabilities on the streets and sought to remove them from the streets. As the science of eugenics took hold in the country, again, it became important to manage the bodies of people with disabilities and to prevent them from procreating. The eugenics movement relied on fear and on pseudoscience, really, to enact public policies to separate people with disabilities from their families so that their bad genes, and I say that with quotation marks, would not burden society. This is a difficult quote to put up here. It's a difficult quote to read, but it is one that I've included here because it demonstrates how underpinning all of these historic laws and policies was the basic assumption that people with disabilities, particularly intellectual and developmental disabilities, were incapable of making decisions for themselves, and that society needed to be protected from those decisions that they did make. Here, particularly the decision to reproduce, to have children. The conception of disability also as a condition that required specialized care, rehabilitation, and curing also had the effect of subordinating the decision-making of people with disabilities to those of experts, medical decision makers, and service providers who would know what specifically was required in order to appropriately care for a person with disability. So sometimes the denial of legal capacity really did come couched in the language of care and rehabilitation. Sorry. It's easy to consign these laws to history, but vestiges of these ideas really persist in arguments that are made and sometimes accepted by courts to deny people with disabilities legal capacity. And perhaps the most striking is the use of guardianship to prevent people with disabilities from exercising their sexual and reproductive rights. When a guardian is appointed with broad powers to make medical decisions on behalf of a person with a disability, People with disabilities are at risk of being blocked from receiving education and information about sex and intimacy. They may not have the privacy to discuss sexual health openly with their physical or mental health providers. A report from the Center for American Progress noted that through news interviews, academic articles, and storytelling advocacy projects, disabled women have made it clear that guardianship was one of the significant tools used to suppress their ability to make decisions about their reproductive health, such as obtaining and utilizing contraceptives, receiving sexual education, and accessing abortion care. Britney Spears' case actually shone a light on the way in which the deprivation of legal capacity could profoundly affect a person's ability to exercise their sexual and reproductive rights. But this is an experience shared by people with much less public profile. Take, for instance, the experience of Mary Moe, a 32-year-old pregnant woman with a disability in Massachusetts who was subject to a petition for guardianship by her parents, who sought to make her undergo an abortion. Although she opposed having an abortion, the Massachusetts trial court actually appointed her parents as co-guardians and authorized that Mary Moe be coaxed, bribed, or even enticed by ruse into hospital for an abortion, and kind of sua sponte also ordered that Mary Moe be sterilized. This decision was reversed on appeal. You have the appeal decision, but her case demonstrates that guardianship can be used in order to threaten the reproductive freedom, autonomy, and decision-making of people with disabilities. And it's striking that this happened in 2012. The National Disability Rights Network has also reported on the case of Carmen, a 22-year-old woman in North Dakota with an intellectual disability, whose mother asked Carmen's OBGYN to actually perform a hysterectomy for her daughter because she had a history of kidney infections arising from Carmen's from purported inability to care for herself during her periods. And the OBGYN agreed to perform a partial hysterectomy before even conducting an examination on Carmen. And this was only resolved when the North Dakota PNA challenged the guardianship in a guardianship court, and the court actually forbade the operation. So we're not talking just about history, we are talking about things that are happening now and that we need to be aware of now. I want to talk really briefly about some consequences that arise when people are unable to make their own decisions. What you have in front of you is Article 12 on the Convention of the Rights of People with Disabilities, which actually separates the idea of capacity from the idea of legal capacity. In essence, for the first time under international law, this provision provides that a person's disability cannot provide a justification for the denial of a person's right to legal personhood. It simply cannot legitimize the deprivation of legal capacity. And in doing so, it pushes states to consider how people with different abilities and disabilities might be supported in exercising their legal capacity. Oops. This is critical because the costs of the deprivation of legal capacity are high. It is a necessary precondition for exercising one's fundamental human and civil rights, including access to justice. International law has long recognized the harms of depriving people of legal capacity, and it's a core principle. The Universal Declaration on Human Rights and the ICCPR, the International Covenant on Civil and Political Rights, specifically states that there can be no derogation of the right to equal recognition for the law, even in times of public emergency. So this is based on the recognition that the curtailing of legal capacity really affects one's ability to be a person, a full citizen, able to make one's decision based on personal values and within a context of meaningful choices. So there is profound value in having one's legal capacity or one's decisions recognized by the law and respected and validated. And conversely, legal scholars and disability advocates have likened the removal of legal capacity to dying a civil death, as one may be deprived, depending on the scope of the guardianship, on the ability to make the most fundamental of decisions, including medical decisions, decisions about your reproductive rights, etc. So, oops, sorry. Once justified as necessary for the protection of vulnerable people, the reality is that the removal of legal capacity through guardianship has not necessarily been borne out, or the benefits of it have not necessarily been borne out in the research. And for example, the National Council of Disability has cited the work of A. Frank Johns, an elder law scholar who writes about guardianship, who surveyed 22 project studies and conferences for a period of 30 years. And he was not able to identify any findings that clearly showed that guardianship led to positive life outcomes. There's some evidence that guardianship can preserve property, but there are also multiple problems with guardianship, including the denial of access, connections, and voice that results from being placed under guardianship and being deprived of legal capacity. Numerous scholars have also pointed out that it has an effect on the state of mind of a person under guardianship. And this, when a person loses the ability to make their own decisions, to be counted as a person with legal rights, they experience a loss of control and a feeling of helplessness that has critical implications for their psychological well-being. And indeed, the label of incapacity may itself have a negative psychological effect on an individual's competency to act in the world. So with that, I'm going to stop speaking, but if there are any questions, I'm really happy to answer them.
So at this moment, Prianka, there's no questions in the Q&A. So maybe we will follow up with some at the end of the program time for Q&A. But thank you so much for that history and background. And one of the things I did not mention when I introduced Prianka is her background prior to coming to the law school, where she was an attorney for Disability Rights New York and spent a fair amount of her time looking at the issues that she's discussing today, and looking at the issues around the incarceration of individuals with intellectual and developmental disabilities, among others. Really brings a robust background and history to our group today. So Prianka, thank you so much for your time, and we'll look forward to chatting again as we get to that part of the presentation. Our next presenter is Mira Weiss. Mira is the founder and managing attorney of the Weiss Law Group. Prior to that, she was the deputy director of Bellevue Hospital. So she is bringing a robust background in health law to these discussions. And in her practice now as a private practitioner, she gets to bring that background and experience, which her practice focuses on health law, elder law, guardianship, and special needs law. So we're looking forward to having her discussion now sort of a little bit more in the concrete about what the standards of capacity are here in New York. So Mira, I'm going to turn the discussion over to you. Thanks so much.
Thank you. And thank you all for inviting me. I have already learned quite a lot. I am going to try and be concrete. I am also going to focus on the more general laws of guardianship and capacity, where it affects our New York state residents, and not focus on the healthcare aspect of this discussion, which there is, I think it is on January 19th, if I'm correct, a program specifically devoted to healthcare decision-making and disabilities. An incredibly interesting topic. Excuse me. The good news is that we have laws on capacity, and the bad news is we have laws on capacity. Why do I say that? Because we need them to function. Capacity, however, is a legal fiction. We can define capacity by prescribing certain laws based on a licensure requirement, based on education, based on age, based on a particular ability to perform a transaction. But then those laws need to be applied. For example, I am very troubled recently by our 6-year-old shooting an elementary school teacher in Virginia. At 6 years old, does that child have the capacity to understand what they were doing? They had the capability to fire the gun. They cannot be charged criminally in Virginia because this child is under the age of 11. If that child is 11 years old, would he have the capacity in Virginia or other states, perhaps, to have fired that gun, to own that gun, to use that gun in an appropriate environment? Each of the states, capacity is a construct of state law. Each of the states has its own approach. There are many, many states which participate in something called the Uniform Guardianship Commission laws. I cite them later on. Each of those states bases its guardianship on the laws within that state. And yet the states have the ability now to come together, not all states participate, to come together and honor each other's guardianships. We recently passed something called Article 83 here in New York, which allows us here in New York to bring an act in court to have an out-of-state guardianship recognized in New York, even if that guardianship is not based on the same procedures and on the same exact standards that we have in New York. This is necessary for us to function. We were quite dysfunctional in the area of cross-state guardianships for a long time, and it has eased the path for people to move from state to state. But it's a very good example of how each of the states manages their definitions of capacity and the application of those definitions in different ways. It's important to know that the terminology of capacity, there is no common definition of capacity. We use capacity, lack of capacity, sanity, insanity, capability, incapability, interchangeably. And as time progresses, we tend to use one term more than another. You may be aware that it is not until recently that we have taken the word mental retardation out of New York State statutes. 2016, we changed Article 17A to remove that term, and recently it was taken out of the Domestic Relations Act and also out of other sections of we changed other sections of Article 17 to upgrade the language to more appropriate terminology used today. In New York alone, there are well over 500 standards of capacity. You may have the capacity to practice medicine. You may have the capacity to practice law. There may be something that you're allowed to do, like drive, that's based on an age requirement, or drink, an age requirement. It can also be a transactional or cognitive capacity standard. And I'll go into some of those in a few minutes. Now, focusing specifically on New York, testamentary capacity. Testamentary capacity is pretty well settled in New York under the Kumstar case, which is cited in your materials, as requiring someone to understand the nature and extent of their holdings, and also to understand who is the natural subject of their bounty. There is a three-pronged test. In California, you must have actual knowledge of those first two elements. Who is in your family, who are the natural product of your bounty, and what is the extent of your holdings. Now, there's an interesting case, which our speaker later on, Honorable Kristin Glen, wrote an opinion on, where the question of testamentary capacity and guardianship crossed over. And at the risk of saying this wrong, and please correct me, Judge Glen, it's the matter of Kazan, I'm not sure I'm pronouncing which way is the correct pronunciation, where it was found that an individual with who was under a guardianship did not have to have the actual knowledge of all of the elements of their accounts, their holdings, that general knowledge, the ability to understand, appreciate, and comprehend that was sufficient for an individual's will to be upheld in New York. I may be at risk of not paraphrasing that properly. At least I've hit the major principle of it. Then we have contractual capacity. We practitioners will say that the capacity to make a will is the lowest standard. The capacity to enter into a contract is immediately above that. And that's what we call a cognitive capacity. Let me get this back. Let me reverse that. This is a knowledge or transactional capacity. You must understand what you are doing, and you must understand the impact of what you are doing. You can't enter into a contract if you are disabled by alcohol or you are disabled by drug abuse and effectively understand what it is that you are agreeing to enter into. That doesn't mean that the contract itself is void. That means that it could be voidable. If you're a minor and you enter into a contract for food, clothing, and shelter, that may be deemed an enforceable contract. But if you are a minor and you enter into a contract for the purchase of an automobile, that is going to be a void or voidable contract because you don't have the legal capacity because of your age to enter into that agreement. Now, we have a knowledge test. We also have the cognitive test, which is the ability to understand what you're doing. So here, if you are impaired because of alcohol, you're not going to understand what you're doing. You cannot comprehend what you're doing if you are under some form of a disability that makes it difficult or impossible for you to understand the nature of what you are agreeing to. So someone with a disability can certainly enter into a contract. The question then becomes, did they understand what they were doing? And did they have the capacity to perform under that contract? Did they understand what the implications of that contract are? Doesn't mean the contract is void. It could be void or voidable, or maybe even questioning the fact that this person entered into a contract and has a disability is a demonstration of a bias or a prejudice against persons with disability. We are not, it's like infinity. It is this is a gray area. You can describe infinity many ways. We understand infinity very many ways. I do not envy anyone who sits on the bench and has to make a decision about the capacity of an individual to be under the control of a guardian, because we are really asking them to be a Solomon, and no one wants to be in that position. Now, if you look at an article, again, this one is by Kristin with Glen and cited in your materials. She gives a very, very good overview of different aspects of New York law in which you can drill down on the impact of that on disability. And I want to focus just for a second on one of those, which is on jury selection. The law in Jury selection. Oh, I'm very sorry here. I failed to put up my slides, didn't I? I'm going to do that. And I am going to share my screen with you. Then you don't have to look at me, you can look at my screen. Okay, can we all see that?
We can see it. You may still need to select slideshow and then play from current slide. But we can see it as it is.
Yeah, but that's not fair. All right, well, you can follow along with the slides because obviously I didn't get that. I didn't get this started correctly. Anyone want to provide some support here? I'd be happy to. Oh, there it is. Sorry. I don't know why you're still getting all of the rest of this, but I'll try and move it for you. Okay. We talked a second about, I just mentioned jury selection. In order to qualify as a juror, a person must be a citizen of the United States. These are very clear standards, not less than 18 years of age. There's an age requirement, not have been convicted of a felony, and be able to understand, sorry, my goodness, be able to understand and communicate in the English language. Now, nowhere in here do we see a standard for competence to serve on that jury, but we have criteria for who can be on the jury. It is left to the commissioner of jurors to determine. Someone was saying earlier that they were having technical issues today. I'm joining you. And I am about to give up. I am so sorry, everyone. All right. I don't know. Anyway, so I'm going to give up on that, and I'm going to talk about it, and I'll talk about it from my notes. The juror has to be able to understand what is being said, and they also have to be able to communicate effectively when they are a member of a panel of a jury. It is up to the commissioner of jurors to make the decision whether or not someone qualifies as a prospective juror and whether or not they should be permitted to serve on the jury. But the commissioner of jurors is not given direction as to how that competence is defined. This is sort of an accident waiting to happen. We don't have any cases, as far as I know, on this yet. But asking the commissioner of jurors to determine whether or not someone is capable to sit on a jury, has the capacity to sit on a jury, is a question that will eventually face the disabilities community. Now, unfortunately, I'm not sharing my slides with you, but oh, thank you. Thank you, thank you. Determining capacity in New York, I want to focus on guardianship from now to the end. Article 81, this is the next slide, is the guardianship that governs adults. Article 81 provides us with a functional approach to guardianship, which is, can you do something? Do you have the capacity to enter into a contract? Do you have the capacity to understand the nature and consequences of your decisions such that you can protect yourself? Are you able to communicate your decisions to others? It is functional. Article 17A, which is another form of an adult guardianship in New York, is diagnosis driven. We'll go into the details just a little bit more in a minute, but it is specifically a statute designed for people with developmental and intellectually disabled conditions and people with physical impairment that makes it difficult to function in the world. Generally, these will have been onset before the age of 22. And it is used when somebody ages out at 18 to create a guardianship, which is called a plenary guardianship, in that it takes away all of their rights and does not require that there be a jury. It doesn't require that there be a hearing. It doesn't require that they appear in court. And the standard for the guardian himself is to act within the best interest of the individual for whom the guardianship has been appointed. It is a much, much more restrictive standard than the guardianship standard for mental hygiene, Article 81, where the person will be found to lack the capacity to manage their person, meaning healthcare decisions, where they wish to live, et cetera, or their property, managing their assets, paying their bills, making decisions about insurance plans. In Article 81, the standard is the person who needs a guardian is deemed to not adequately understand and appreciate the nature of their cognitive impairment. And as a result, they're likely to suffer harm from that. Take, for example, someone who has Alzheimer's. You may have the capacity to read a spreadsheet. I have this incredibly interesting client who has the capacity to read spreadsheets and make decisions with regard to his investments, but he can't determine when is the appropriate time to take a shower, change his clothes. He cannot take his medications on time. You can have the capacity to perform in one area and not in the other. So in a guardianship under Article 81, it is tailored to the needs and then made in such a way that honors the most independence of that individual, whereas opposed to in a 17A, there is a basic understanding that if you have an intellectual or disability or a developmental disability, which has been documented by physicians and reviewed by the court, that you do not have the ability to manage your person or property. And it affords the least amount of independence. There is a case recently, which is not cited in your materials, matter of grace, but I can put that up there. Under matter of grace, we come to, and if you'll change the slide, we come to Article 82, which is where we talk about supportive decision-making. And this is kind of a hybrid. It will allow someone who is in need of a guardian to participate in decision-making under now the 17A for persons with intellectual disability or with a developmental disability, to participate in decision-making on their own behalf. The matter of grace is a very good example of where people became dissatisfied with Article 81 and Article 17A being in opposition to each other, that you had one group of laws which allowed an adult to be in a less restrictive environment, and Article 17A, which said you have no rights at all. The supported decision-making and the way New York has developed its law of decision-making to incorporate this hybrid is a change which is now taking place all over the United States. And as Prianka was talking about earlier, has certainly been adopted in the international community. If you wouldn't mind, change the slide there for a second. I want to go to the 2 slides ahead to who decides. I don't have a lot of time left. And who decides is the last slide on our program here, second to last slide. I put these two articles up here as examples, very telling examples of the conflict between affording an individual the right to their own decision-making and compelling an individual to accept the decisions of others on their behalf. This article from 2018 was written in the New York Times by a woman who is, at the time she was 77, she was a Columbia master's degree individual. She had quite a lot of money. And at some point, her mental disability made it not possible for her to function as a normative person in society. She was placed under a guardianship, and eventually her rights, this was in Article 81, were virtually entirely curtailed. She writes a very compelling case for why this guardianship should be removed, and she should be allowed to make her own decisions to live in a way which is antisocial. Who decides? Was she right? Is she wrong? Is she competent? Is she incompetent? Is she acting in a way that society doesn't like, and therefore, like those ugly laws that Prianka talked about, we want to put her away? Or is she acting in a way that she needs protection in order to function in society, and we as a society have an obligation to help protect her? Then we have another article, and this is very, very recent. This is from 2023, it says 2013, where there is a woman whose sister is very, very, suffers from severe mental illness. And the sister argues that Kendra's law, which allows people to be taken off the street for outpatient treatment against their will, is the best thing that possibly could have happened for her sister. It has saved her sister's life. It has made it possible for her family to function again. Who's right? The sister with the mental illness would like to live on the street. New York State now says, we don't want you to live on the street. We believe that we must come in and help and determine whether or not you were in the care of outpatient treatment without your consent. We've had laws on the books for a long time that allow commitment of persons for a limited period of time in an inpatient setting. The standard for that is someone who is a danger to themselves or to others. The laws for competency capacity change over time. They are subject to interpretation. It is an ever advancing subject. It's incredibly interesting area to practice in, and it's a very, very, the arguments on either side are very, very compelling. I wish everyone who works in this area the best of luck as we're trying to move forward in bringing the supportive decision-making into function within the court system here. I think it's a wonderful thing for us to do, but I do understand that there are people who are greatly opposed to it. With that, I'll ask if there are any questions. And again, I apologize for the lack of technical ability here.
Thank you so much, Mira. At this point, no questions, but I know we're going to put up our first CLE code at this point. So Shell, if you could take care of that, that would be great.
Yep, that's right. So let me just share my screen. So the CLE code word, for those of you who are seeking CLE credit, The first code word is change, C-H-A-N-G-E, change. All right, thank you.
All right. Our final speaker today is Judge Kristin Booth Glen. Judge Glen, for those of you who do not already know her, is the Director of Supported Decision Making New York, as well as the Dean Emerita of the City University of New York. City University of New York. I was going to say law school, but I know it's the City University of New York. Judge Glen has spent, prior to those roles, 12 years in private practice and 15 years on the bench. In her bench time, most notably, certainly for many of us who are in attendance who are attorneys in this area of practice, she served 6 of those years as the New York County surrogate, where she authored a number of decisions that have challenged the paradigm that we have been functioning in New York for a great number of years with respect to the construct around guardianship and fiduciary responsibility to individuals with intellectual and developmental disabilities. Today, Judge Glen is going to speak to us about the Article 12 Convention on Rights and Supported Decision Making, among some other comments. So, Judge, thank you so much for being with us, and I'm going to turn the floor over to you.
Judge Glen, we cannot hear you. You're muted.
Sorry. This is not the presentation that I expected to give, and probably not the presentation that Rosemary and others who organized this expected me to give, for several reasons, which I'll explain in a moment, and also expose myself to incredible humiliation. But I want to make, I think, 3 comments on what I've heard already. One is, Tara, thank you very much. You just made me 7 years younger than I am, which means I have a lot more time to try to change the world. I actually was on the bench for 15 years, left to be Dean of CUNY Law School, and then came back as surrogate. So there's another 7 years there. For
oh my goodness, well, I apologize for that.
No, that's okay. But I was, in my first 15 years, I was, deeply involved in Article 81. So my experience with guardianship goes back a long way. I want to share with Mira the tech problems. I know that I can't advance slides, so I have asked, I think Rosemary or Shell, who's going to do it for me. So that's another shared thing. And I just want to say one thing, Mira, I don't want to criticize this, but the statute 81 is a good statute. It has a lot of really good provisions, and it really does speak explicitly about least restrictive alternative. It speaks explicitly about tailoring. It speaks explicitly about, really only granting guardianship over the things that a person can't do. And earlier this morning, I was doing a webinar for the new judges school, partly on Article 81 with Surrogate Guy from Binghamton. It's a great statute, but with all of that, the estimate is that more than 90% of all Article 81 guardianships are plenary. So you can have a good statute with all the provisions, and you can have an alternative disposition like 8116B, which is what we call the one shot. And I would like to call everyone's attention to it. But at the end of the day, if people don't use it and don't come to it with a lens of preserving and protecting people's rights, what you end up getting is taking people's rights away in ways that are absolutely not necessary and unjustifiable. So that's the bad news. All right, so now my humiliation. Actually, not my humiliation first. I do extensive slides, not because I want to read from the slides, and I hate people who do that, but because I intend them to be just sort of a resource for the participants, and that was what I wanted to do for you here. But apparently, I have just learned, as I see what was sent, that although I had started to work on these slides last Friday, including, taking, cutting and pasting some slides from other presentations, but really trying to create something new. And then I worked all day Sunday, and I have a really nice set of slides that is exactly what I wanted to talk about. But somehow the draft from Friday is what got sent to the Albany Government Law Center. So I'm going to kind of do slides up to slide number 15, and then we're going to stop and I'm just going to talk. I'm really sorry. This is like one's worst fantasy, and it has just come true. And I am really, really sorry about that. But there we are. And then the other thing is that I was told I was supposed to talk about human rights. So I was very excited because I never really get to do that. I want to, and it's where everything that we do at Supported Decision Making New York comes from. It's really premised in human rights. But parents and stakeholders and so forth want to know, what is supported decision making, what do you do in your facilitation, et cetera. So that's what I ended up talking about. So I was really excited about being able to do this. But Prianka, did such a great job that much of what I might have said, although, I explained where human rights comes from originally, but you don't need to know that. So bear with me. I'm going to do the best I can in a relatively short period of time. And please do not consider anything after slide 17, because as you will see, there are a few slides there that were for a presentation to project guardianship that really don't belong here, although there's nothing secret in them that you can't know. And you will have the good slides, and I will send them to you soon. So, okay, let's start with these slides, because we can segue into what follows from all of the wonderful presentations we've had so far. Okay, so we've started at great length with what guardianship is, how it's based on this notion of capacity, how guardianship is often is really thought about as mental capacity. Sometimes we talk about it as functional, whatever. Mira covered that at some length. But whatever the law says, including 17A, which seems to say, you got a diagnosis and somebody thinks it's a good idea, fine, we'll take your rights away. There is a constitutional overlay, and that overlay comes not from Olmstead, which is of course a statutory decision, but it comes from decisions of the Supreme Court that at least at this moment are still good decisions, and also separately from our Court of Appeals based on our own New York State Constitution. These cases are cited in the article of mine that Mira gave you, and I can give them to you separately. But the principle is that when the state is interfering with someone's rights, whether they're property rights or liberty rights, in order to protect them as opposed to protect others. I mean, we interfere with people's rights to protect others through the criminal law and putting people in jail, and then they don't have any rights. But if you're doing it to protect somebody, then you can only do it if the intervention is the least restrictive intervention available. So you always have to ask the question, is there something less than this kind of plenary guardianship, which really is the norm, even in 81. So overlying everything, there is this constitutional imperative. Okay, next. Next slide, please. Okay, so the limitation of where we are right now is that we're always asking, what can't a person do? Can they not balance their checkbooks? Can they not figure out what time it is to take a shower? The kinds of issues that Mira just talked about. And that assessment is also always, virtually always, made just thinking about the person completely alone. I think Duncan Kennedy once in some law review article talked about it as a tub in a field, as opposed to surrounded by other people. So, I used to think in guardianship hearings, when I would have the person on the stand, the idea that you could ask a person who, clearly has some limitations and is probably unbelievably frightened to be in court, how do you make this decision and expect them to actually tell you to do it? How they do it is just not possible. And the real question is not what they can't do, and not only what they can do on their own, because that's not the way people make decisions. So first we have to interrogate this notion that everybody makes rational decisions. I mean, this is the history and the consequence of the Enlightenment. We are all rational people. We make rational decisions. We don't. And we know that now because the last 15 or 20 years, particularly in neuroscience and behavioral economics, have demonstrated to us that the decisions that we think are rational are not rational at all. I mean, the different parts of your brain are operating. Decisions are often made before you even know what they are. There's all, I mean, there's all the stuff about heuristics. You don't need to know all of this, but trust me, there is a huge amount of evidence out there that we are in fact not the rational beings that we would like to think that we are. And for example, 3 out of, I think, the last 13 Nobel Prize winners in economics have exactly demonstrated this and talked about. So when we ask what a person can't do, when we look at them just by themselves, like, can you do it by yourself? Which now we know people don't do, then you get unnecessary guardianship and the loss of fundamental rights. Okay, next slide, please. So this is why I really like human rights as a way of thinking about these issues, because you start from the place, and you saw Article 12 and Prianka talked about it, that everyone has a right to make their own decisions and to have them legally recognized. And unlike a lot of stuff in New York law, which again is in my exhaustive and exhausting article about, multiple zillions of different capacity standards, it's not a rebuttable presumption. You just have it, right? And because you have it as a human rights matter, the government has an obligation to provide you with the supports that you need to exercise it. That's the human rights framework. So if you accept that framework, then the question is not, what can't this person do? So then somebody else will have to do it for them, but what would it take to enable them to do it? Okay, next slide. So how does the human rights lens apply here? We already know, both from what practitioners do, we know from some of the supports that are listed in Article 81, that there are a lot of supports for people who have IDD or cognitive decline, where they're not able to make their own decisions, but where a support obviates the necessity for guardianship because it is a less restrictive alternative. So, if a person can't handle their Social Security payments, get them a rep payee. If a person can't really handle a lot of money, then you can have a support, an SNT or ABLE accounts, et cetera. And the law recognizes these things as less restrictive alternatives, healthcare proxies, for example. So if what you are doing is taking this least restrictive alternative standard, which I've already said comes from both the federal and our state constitution, and you are applying the human rights lens, then the question is, what supports would this person need to be able to make their own decisions instead of having someone else make these decisions for them? I'm sorry, I said I wouldn't read from, but I mean, that really is the question. So if the question is what supports, that brings us to, next slide, supported decision-making. And presumably what in the very short period of time I have to talk with you, a question is, what is it? Where does it come from? What's happening in New York about supported decision-making? And for those of you who are practitioners, like, how does this affect your life, and what could it do for you in your practice? What kind of a resource could it be? So next slide. So I like this definition of supported decision making, which comes from a friend and colleague. Which comes from a colleague at American Law School, Bob Dinnerstein. Because it speaks to the sort of multiplicity of what supported decision-making it is. It's a series of relationships, practices, arrangements, agreements of more or less formality and intensity. But at bottom, whether it's a relationship, a practice, an arrangement, an agreement, whether it's formal or not formal or intense or not intense, it's all about enabling individuals to make and communicate decisions about their own lives. That's what it is. Okay, next slide. So where does it come from? The human right, I think we've talked about, and I'll say a little bit more later, but I think it's really important to see that there's an empirical basis here. And the empirical basis is how we all make decisions. When we started doing supported decision-making under a grant from DDPC, like now 7 years ago, I guess, we drew on the work of pilot projects around the world because because of the United Nations Convention on the Rights of Persons with Disabilities, the CRPD has been ratified by every country in the world with the exception of the United States, South Sudan, and North Korea, which could raise some issues for you about the company that were in there. But because of that, there were many pilot projects going around the world, highly developed ones in Bulgaria and the Czech Republic, in Israel, and in Australia in particular. And all of them had developed various kinds of facilitation models. And they all had sort of questions about what areas do people want assistance in, what kinds of supports do they need, and who do they want to get it from. And so when we started out, we were asking decision makers in the process that we've developed, which I'll talk about very briefly in a second, what kinds of supports do you want? And they had no idea what we were talking about. And in a certain sense, we didn't either, because we realized that we had to explain what went into making a decision. So now the next slide is the money slide. I love the money slide. Okay. Keep this slide, like think about this slide, because it turns out that everybody makes decisions using 7 steps. And the way I know this is because now there is a whole niche industry that has grown out of this other research that I talked about how we don't make rational decisions, in which people who are the captains of industry, the heads of major corporations, particularly in the healthcare world, people high up in the military are being taught how to make good decisions. And everybody breaks it down in this way. These are the 7 steps. And you could go through, and if we had a lot of time, it would be fun to do it, go through some important decision that you've made recently, and you will realize, whether you thought about it or not, that you gathered information, that you had to understand it, that you had to think about alternatives, that decisions are not always binary, yes or no. There might be, it's not, do I only have this medical procedure or not? Is there some other medical procedure? Is there wait and see, et cetera? Understanding the consequences, not just of making a particular decision, but also maybe of not making that decision. Then you weigh all those alternatives, which is actually making the decision. Then you communicate it to others, and then you implement it. That's what everybody does. That's what you do. It's what I do. I actually worked with some judges thinking about how when we write complicated decisions after 6-month jury trials, we do all these things. We follow these steps. The kinds of support, gathering the information is, not just the testimony, but also the references to the cases that people are relying on, and then understanding that by reading the other cases or the restatement or whatever, and then considering how you could go, and then understanding what that consequences might be, not only for the parties, but for the law. And then you decide, and then you write your opinion, and then you send it to the law journal and hope they'll print it. And then you go out and talk about it. So we all do this. And people with intellectual and developmental disabilities or other kinds of cognitive disabilities do exactly the same thing. It's just that they may need more or more intense supports. So now I want to go back to the variables from Bob Dinnerstein's definition, which is that there are different kinds of relationships, arrangements, and practices. So supported decision-making can happen in a completely informal way. It does. There are probably tens, if not hundreds of thousands of people who had IEPs in special ed, who receive or have received services from OPWDD, and not very many of them are under guardianship or as a percentage. So they're out there, they're functioning, they're getting supports, they're not calling it supported decision-making, they're doing it, and they're fine. There are degrees of formality and intensity. So you can do an agreement with your supporters, and it can be kind of an informal agreement. There are DIYs from many states about how you can make supported decision-making agreements. You can go through a formal process, which is what we do at Supported Decision-Making New York, that ends in a supported decision-making agreement. You can have a legally recognized supported decision-making, which we now have as the result of Article 82, although we don't actually have it yet. What we have is the legislature saying that for people with IDD, once OPW has drafted regulations about the kind of facilitation they need in order to make their supported decision-making agreements, then decisions made pursuant to those agreements must be recognized by third parties. And in return for that, third parties get immunity from legal and from civil and criminal liability, and also from any professional discipline, if somebody takes something as an informed consent. So they just have to accept the decisions that are made under SDMAs. When we also think about the variables, it's like the different groups that are involved in this, the different groups that are covered by Article 12 that Prianka talked about, the different groups whose dignity and autonomy and respect is taken away by guardianship. And really there are four. There's the folks that I work with, which are people with intellectual and developmental disabilities. There are people with psychosocial disabilities. Now, if I can just remember, since we've gone through the slide, there are people with psychosocial disabilities, and then there's people with traumatic brain injuries. And basically, so yeah, it's fine, go to the, and then there are the kinds of decisions, right? People make little decisions about what am I going to wear today? What am I going to eat? And then there are big decisions like, am I going to have this surgery that could result in my death or keep me alive? Or am I going to invest my money this way? Or am I going to move out of supported living and live on my own? Or big decisions, right? So there are all kinds of decisions. There's ranges of decisions. There's ranges of the ways people make them. There's ranges of the intensity and the formality, et cetera, et cetera. So all those things are the variables. We have tackled one of those things. Okay, now, next slide. So we have one practice with one degree of formality for one group. And as I said, that's because we had the benefit of work that had been done around the world and work that led us to supported decision-making facilitation as a process. We piloted under a DDPC grant. We train facilitators. They work with the persons with IDD, who we call decision makers, in a 3-phase process, which is described here. And that's what we do. Next slide. This is humility. So this is what we do. So it is what I just said. Let's just move on to the next slide. So here's what we don't know, right? No one claims, we do not claim that everybody can, right now, we know enough about how to help everybody with intellectual and developmental disabilities. I would say that what we do probably works for somewhere between 60 and 70% of people. And then there are people whose impairments are sufficiently severe that we just don't know yet what the right way to support them is. It's not that there isn't a way, it's just that we don't know it yet. And it took us, it took the world community, 10 or 15 years to figure out how to do it for the people we do know how to do it for. And hopefully we will keep moving down into more and more severe disabilities to do that. And we also know that a lot of people don't have natural support networks. It's really easier for us to work with 19-year-olds who are still involved in the skills or whatever it is part of special education, and who are supported and who generally have families that they live with and who support them, as opposed to people who maybe have been living in congregate facilities or group homes or whatever for many, many years and really don't have any natural support systems or viable supporters. And that's a complicated issue. What we know is that what we have developed for this group does not transfer automatically to the other groups. It absolutely doesn't. We have to figure out for them what supports they need to be able to make decisions on their own. And I will say right now that one of the really good things about Article 82 is that it recognizes that we have done the work for people with IDD, which is why the legal recognition of decisions made pursuant to SDMAs under a facilitation model for people with IDD are going to be recognized. But the legislature specifically says in Article 82, we need to do the same work. We encourage government agencies and civil society to do the same kind of work for people with cognitive disabilities and for people with psychosocial disabilities as has been done for people with IDD. So the call is out there to do it, and it's a whole area that, please do it. Like, this is a change the world opportunity, and hopefully some of you will be brought into it. And then just let me see this last slide. Next slide. So this is just a slide that I put in about why it's really important to do this for older people. I mean, this is where I started out. I started out with 81, and which is mostly older people with cognitive decline and dementia. And as I am now 80, I am thinking about what it's going to be like if I develop cognitive decline or dementia, if I haven't already demonstrated that by sending the wrong set of slides. And so your sense of yourself as an agent in your own life is so critical. Again, Prianka spoke about this, very beautifully. So I'm not going to say anymore. So now I'm just going to very quickly say what we're doing in New York. So there's Article 82. I think I've said a little bit about what it does. It doesn't say necessarily that people who should have guardians can do this as a practice. It says supported decision-making can be a less restrictive alternative. And we now have a lot of decisions from surrogates around the state, again, who have nothing in the statute that they can turn to, nothing like 81, who say, even though the statute says best interest in diagnosis, there is this overlay of less restrictive alternative. And with this person who I see in front of me, whether it's Grace in the wonderful Grace decision, or a young person who is referred because the school tells every parent when their kid turns 18 that they should go and get guardianship, that the surrogates or their court attorneys or GALs or whatever are looking at these folks and saying, wait a minute, they're asking the question that I asked, which is not, can this person really make all their decisions right now? Which I would argue also that neurotypical kids at 17 and 18 or 19 don't do all that well. But what would it take? And would having a supported decision-making system in place make it possible for them to do that? And that's what the statute says. And so surrogates are saying, you know, I'm not going to decide this now, I'm going to adjourn it, or I'm going to appoint a guardian, but you have to come back in 6 months, or, you know, please go talk to Supported Decision-Making New York or whatever. And we're hearing this. The statute does not tell people they can't get guardianship. It does not tell people they have to do supported decision-making. There's a lot of misinformation out there. What it says is supported decision-making can be a less restrictive alternative in an individual case for a person who would benefit from it and who with that support would be able to make their own decisions. So that's Article 82. Then very quickly, Supported Decision-Making New York arose out of a 5-year grant from DDPC to like figure out how to do it. We have figured out how to do it. We've got supported decision-making agreements from now well over 100 decision makers. We got a bridge year because of COVID from the Ford Foundation, and we got this legislation. And as a result of the legislation and as a result of what we have demonstrated works, OPWDD has given us a 3-year grant to develop a model for a statewide delivery system. Because if now everybody says, oh, well, we could do supported decision-making instead of taking away your rights, how are people going to get this facilitation? So what we are doing is developing a model which would permit the facilitators who are trained and who are the critical sort of one-on-one with the decision makers and the supporters to come from a variety of places, from provider agencies. Chris Lyons, I know, is on this call, and AIMS is one of those provider agencies that we're working with. They could come from the private bar. We would like to see the private bar be able to offer supported decision-making as an alternative to petitioning for guardianship where that is appropriate for the individual and their family, and to get paid for it so that, you know, there's no financial disincentive. So that's a part of it. We also look at things like MSW students who could do facilitation as part of their field work. So we're looking at facilitators coming from a wide variety of places. We're looking at decision makers coming from a wide variety of places. The legislation has clearly incentivized families to seek this, either because they're afraid that they're going to spend money to get a guardianship and then have the judge turn them down, or just because they really want an alternative and they never knew there was one. And then there's a central entity, which sort of we are, right, supported decision-making is right now, but we're transforming into a model whereby the centralized agency would provide all of the facilitator training, all of the facilitation materials, and all of the mentoring, which we found is critical. So every facilitator meets with an experienced mentor after every meeting with the decision maker or the decision maker and their supporters. And this is the way that we can assure that the facilitation that is offered by a DSP and an agency in Plattsburgh is the same and as good as and has the same integrity as one offered by a private practitioner in Manhattan or by an MSW student at the University of Rochester. So that's what we're doing. And the kind of bottom line of all of this is that we are accepting referrals. If you are private practitioners and you have clients for whom you think this might be a better alternative, you can refer them to us. If you're in a court and a surrogate says to you, you know, I think maybe this person doesn't really need a guardian, you'll know that we're there, we're offering the service. And I don't know whether I do or not, and this is your call, Tara and Leslie, and I don't know what kind of questions are left. I have a 3-minute and 36-second video of one of our decision makers, which I think would be so much better than anything else that I've said. And if we have time, I'd like to show it. And if not, we'll just somehow add it to the materials so people can look at it.
Sorry, I was muting myself. You absolutely have time to show it. We've got about 15 minutes. There's a couple of questions, but I know it's a shorter videos. So why don't we show that, and then we'll go through the questions that are on the in the chat.
Okay, and let me just say one thing about this. Jessica is reading from a script that she wrote because she, as the decision maker, wanted to read from a script that she wrote and not extemporaneous, and nobody told her what to write. This is her statement. Okay.
Okay, I'm about to play it. If anyone cannot hear it, let me know.
Hello, my name is Jessica. I'm here to tell you about supported decision-making and what it means to me and many other people with disabilities in New York State. Have you ever made a wrong decision? One where you think back and say, oops, that was the wrong thing to do. Like getting a parking ticket. How did you move forward? Did you learn from it? Or did you stop making decisions altogether? I doubt that. I'm here to tell you that the possibility of making a bad decision or a good decision at all is a privilege, one that I want and deserve to have in my life. You can see a person with a disability under guardianship cannot make any decisions, good or bad ones. The mere possibility of making a bad decision strips us of our right to live a full life. A person's life is a collection of experiences, all kinds of them. And I am just like any other person. I want to live it all. Living a full life means that I deserve to have dignity of making a mistake. The chance that I could sometimes forget my umbrella on a rainy day must not mean that I should never be allowed to walk outside. Supported decision-making empowers me to take ownership of my life. It solidifies my connection to a group of people who want to see me move forward. They are not there to hold me back or warn me at every turn. They are there to help me get all the information I need in a way that I can best understand and ultimately support me in the decisions I make. In my case, it also means that my closest caregivers see me thrive with the support of others. They don't always have to be there for me to give me confidence. They know that I can stand on my own even when they are not there available to me. I've done the work of developing these supportive relationships. It is not only right that I can benefit from these deep connections. My team of supporters trust me to be able to make decisions. They believe in my goals and in my capacity to understand choices and take risks. I am a passionate advocate for people with disabilities. I work for the Self-Advocacy Association of New York State and AHRC Nassau. I want to tell others like me that they deserve to be the architects of their life. That needing help from others does not mean that they are not capable of making their own decisions. Supported decision-making is a transformational program that makes me feel excited about my future. It helps me take ownership of everything I do. It pushes me to build critical thinking skills. And most importantly, it allows me to be fully contributing member of society. An inclusive world that truly supports people with disabilities has to let people live life the way they want, to go on their own terms with the support they need to do so.
I love the architect of your own life. That's her. That's from her.
Thank you, Judge. Couple of questions have come up in the chat, and I want to.
Tara, if I may.
Yes. Oh, I'm sorry. Yep. Go ahead.
We have one more code word to share for folks who are looking for CLE credit. So give me one moment. There we go. The second code word is rule, R-U-L-E. You should see it on the screen. Again, that second CLE code word is rule. Thank you.
Thanks, Shell, appreciate that. Apologies. Couple of questions in the chat. The first is Judge Glen, related to the global research that you referenced in your presentation. An attendee just requested, is the underlying global research and data that you referenced published? And if not, can the examples that your group considered be shared?
I don't know that I said global research. I think I said global practice. Although there is a lot of research that comes out of Australia about support and about developing capacity for supporters to actually move from paternalistic roles to the roles of supporters, which is, which we all have to do with our neurotypical kids somewhere between the ages of about 15 and 30, if we're lucky, usually with a lot of screaming and yelling about it. So there is that research. And then in terms of the discussion of the pilot projects and so forth, there are, I'm sorry to cite myself, but there are a bunch of law review articles, including one very good one in the Albany Government Law Review. Thank you very much, Albany Government Law Review, which is called Reflections from a Pilot Project, in which I talk about where we have drawn from other places and what we do with some degree of certainty. There's an article in, I'll send all these to Rosemary if she doesn't have them. There's one in Columbia Human Rights Law Review. And then most recently, there is an article in Syracuse called, which I co-authored with a couple of other people, called Lessons from the Pilot Projects. And it's mostly about pilot projects here, but also around the world. So whatever there is in those articles. One of the problems is that a lot of this stuff is published in journals that as lawyers, we don't have access to. There are all these like, and you have to buy the articles. They all cost like $42 or $68 or something. If you're in an academic institution, your library maybe can get it for you. If you're not, you're just sort of at a loss. So there's a disconnect. And then of course, a lot of it is just not in English. I mean, there's like fabulous stuff going on in Iceland and virtually none of it is translated. So what there is sort of out there in the articles that I will cite for you.
And I do believe that in one of the articles in the materials that was authored by Judge Glen, there is some reference and citation to some of the global practices that created the conversation here in the States and certainly in New York. Second question, and this is for the panel generally, is would speakers please address Article 17A guardianships and voting rights? And I think this is an interesting question because every time we talk about it, we talk about different answers to this question. But it's a general question, which is, what is our understanding relative to the voting rights for a person under Article 17A? Judge or Mira, I don't know if one of you wants to respond to that, but it seems to me that one or both of you would be the best responders.
Well, this is
go ahead, Mira, you do it.
I said, this is one of the, it's exactly the situation that I was talking about, where we have a voting rights law, which talks about incompetence, and we don't have that as a standard that is defined anywhere else in the law as it pertains to voting. So how do we determine if somebody is incompetent or competent not to vote? That is not part of what the language of guardianship. So I will leave it to Judge Glen to speak more on this subject, but it's an excellent question and it's the perfect example of how we do not we have a good thing, but we also have a bad thing. We want people to vote. We don't want people who shouldn't vote not to vote, but we haven't defined really well who that group is.
So I just say, this is just a huge mess. I mean, it's a mess everywhere. There are about 500,000 articles. There's no definitive decision in New York about what it is. But for me, the argument is pretty simple. This is basically in Article 81. It's pretty much implicit in Article 82. Every adult is presumed to be competent or capacitated unless they are found otherwise by a court of law. So my view is, if you're not under guardianship, you are competent to vote because you have to have that competence taken away by somebody in order to not be able to vote. That's the way I read it. And I would hope that if it ever gets up to the Court of Appeals, that's what the Court of Appeals will say. But
and so if you are under an 81 guardianship, that doesn't explicitly remove that right, then the position would be that you do have the right to vote. But under 17A, because there is no explicit determination, people are left with whether or not they have the ability to do it. And of course, there's no policing really around it in any way, in lots of different arenas, not just in the disability arena. So I think
I think what you're going to see is where people have visible disabilities, like people with CP, where, you know, the county clerk the voting clerk thinks that they can't understand what they're saying, so they must be incompetent. It's just like people, you know, yell at blind people or whatever. That you may want to cite to the law, and you may want to talk about the fact that people are presumed to be competent unless otherwise. But in the, you know, you can litigate it, but it is what it is.
Yeah, I think if that question getting asked among any different group of people would elicit a multitude of different answers if it was specific to article. Well, not a multitude. Some would say yes and some would say no. There's not, I guess, a multitude of answers you could have there.
I think, I'm sorry, the point I wanted to make was I think it's really useful for practitioners, if they can, to do guardianships by consent rather than the imposition of a guardianship over somebody's rule, because that does not involve a finding of incapacity.
Right.
So if you have a guardianship on consent, you should still be able to vote.
There you go.
Just one more comment on that. I actually do know of a situation where a blind person was denied the right to have someone come in and read the ballot to them. So it's not just intellectual disabilities, it's also physical disabilities where this becomes an
And
issue.
that violates the ADA. So there you go.
Thank you guys both for responding to that question. And then there's just one more sort of general question that came up, and I'm not going to ask it in quite the way that it was written, but generally, and I think you know, for everyone who spoke, who wants to respond, and we'll close with this question, but one of the questions that was written in is on sort of the overall philosophy around guardianship. And I just want to make sure everybody is clear in comments and discussion. And I think Judge Glen, you did say this in your presentation, but the comments that are here, the different methodologies and alternatives that we're talking about here, no one is sitting on this Zoom, I don't believe, although this is the question, is there anyone here that doesn't believe that guardianship in some form or another is appropriate in certain circumstances? We're not saying there is never a circumstance where guardianship in some way is going to be appropriate, or are we, or are any of you saying that?
Certainly not right now, but we'd like to move towards that. We'd like to know supports that we could give everyone so that they don't have to have this right taken away. But right now we don't have it. So what we need to do is find the supports, and where we have the supports, we need to use them. And that's what's called less restrictive alternative. And that's what you always have to look at in terms of guardianship.
I think we absolutely do need guardianship. You have a situation where in the worst case scenario, someone, because of a physical situation, is unable to take care of themselves, and they have failed to put a power of attorney together. That's the simplest case where it's obvious that someone needs a guardian. They cannot express their wishes. They can't about their health care. They cannot manage their finances. And during this period of time when they're have this physical disability or perhaps mental disability, which makes it impossible for them to manage their own affairs, they do need someone else to come in and assist them. So there is a place for it.
Thank you, Mira. Roger, Prianka, any comments?
Yeah, I think it's worth noting, you know, so the bill establishing Article 82 was something that was advanced as a departmental proposal by OPWD, and in that, you know, we were always very clear that this was to be an alternative to guardianship, and you know, so I think one can debate about, you know, how many people would benefit from one versus the other. I did want to say that for the audience, there's a process that's ongoing, led by OPW Counsel's Office to engage and develop regulations. So the structure of the statute is such that it's fully effective upon a relevant oversight agency developing regulations. So there was a fair amount of feedback as the bill was moving through the legislature around the practicalities, and then those are intended to be addressed in regulation. So I'm presuming the audience for this is one that's very interested in the topic, and it would be worth reconnecting on that as those get developed over the course of, well, it was a year from the bill's enactment in July. So over the course of the first half of this year.
Thank you, Roger. Any other comments, Prianka?
Yeah, I guess I will say that guardians are typically people who are looking out for the welfare of the people who they are taking care of, or who they have been given this responsibility for. And I don't think in any way that responsibility and that care should be disregarded. It's an important role that individuals are playing. And I think to the extent that that has not been, said explicitly by me anyway, I want to respect that. I do feel like that's an important thing for me to respect. I'm hoping that as a society, that we can make some structural changes, and those structural changes mean moving further and further away from guardianship as the solution or the most helpful solution for people who are interdependent, who don't just make decisions for themselves. Like, how can we replicate that interdependence for people without taking away their decision-making power, even though they may have significant disabilities? And I think we need to be developing those mechanisms. So the question is always, what's next? Without stepping away or without failing to acknowledge that people who do serve as guardians do frequently serve an important role and are doing it from a place of care. Frequently, sometimes it's not. Sometimes, but a lot of family members do very much care for the people for whom they are acting as guardian, and I just don't want to ignore that in the course of this discussion.
Thank you so much. We're getting to the time where we're at the end of the presentation. There's one final question, and then I just want to remind folks about the CLE component. But before I do any of those things, I want to thank Judge Glen, Mira, Prianka, and Roger for their time and expertise and this really great sort of broadly encompassing discussion today. And as we all know, this is really, as it has been over the years, we are, as Judge Glen identified, we're really at the beginning of this discussion and the different supports and alternatives that will be implemented and utilized, hopefully over time. And to your point, Prianka, that the paradigm changes to some extent. So thank you all so much. Mira, a question was asked about an event discussing healthcare decision-making on January 19th. Is this an open webinar, is the question there. And since you referenced that program, I just wanted to let you identify what that was for the attendees.
What I was referring to is the next thing in this series where we're going to be talking about healthcare, where the discussion, I understand, is on healthcare decision-making and disabilities.
And so that is a program that the Government Law Center is putting on. And in the chat, the GLC has been identifying and adding information about that. So please take a look and register yourselves if you would like to do that. Very last comments are that for those of you looking for CLE credit, we did provide both codes. The form was emailed to everybody. It needs to be downloaded, signed, and emailed to Lisa Ravage. So when you go back to the email you received that gave you the link to this webinar, that's where you're going to find the form. So please take those steps as identified and turn your CLE forms in. So thank you all very much for attending. And thanks again to our presenters. Judge Stein, any closing comments that you'd like to make?
I just want to say from someone who does not have a lot of background or experience in this particular field, I thought that all of the panelists were just amazing in the information that you provided, and you really set the table for the further discussions on more discrete areas in this subject area. And I think it was just a remarkable program, and thank you all for your time and your expertise and sharing it with our audience. And I'm sure that the evaluations will reflect just how excellent this program was. So just a great big thank you and applause to everybody that made this happen.